Hello visionaries, welcome back to my channel. My name is Marisa Talbert. I'm the founder and CEO of Talbert Law Office, your favorite go-to legal resource for all things business, nonprofit, and intellectual property law. Of course, I'm here to inform you and break down the latest legal news and what it means for you. Today we're talking about something that impacts millions of workers and businesses across the United States. It's the recent decision to strike down the federal non-compete ban. So if you don't know, earlier this year, the Federal Trade Commission proposed a nationwide ban on non-compete clauses in contracts. These types of agreements have been pretty common in industries across the country. Essentially, they prevent employees from working for a competitor or starting a similar business for a certain amount of time after they leave their job. The FTC's argument was that these types of clauses stifle innovation and limit an employee's upward mobility. So the FTC decided to ban these non-compete clauses, which was set to take effect September 2024. The FTC's conclusion was that banning these non-compete clauses would increase wages by $300 billion annually and would give employees more freedom in choosing their jobs. But fast forward to now, the proposed ban has now been struck down. Federal courts ruled that the FTC overstepped its authority by imposing a nationwide ban on non-compete agreements. Essentially, the court said that these types of issues should be handled state to state and not on a federal level. Several states like California and Oklahoma already have very strict limits on non-compete agreements, while other states allow them more freely. With the federal ban struck down, states will continue to determine how they handle non-competes in their own jurisdiction. So what does this mean for you as a worker? Well, first off, if you're in a state like California where non-competes are already heavily restricted, there may not be much change for you. But if you work in a state where non-competes are freely allowed, this court decision may encourage workers to push for more favorable terms in employment contracts. It's just a reminder to always be aware of what you're signing and negotiate whenever possible. On the other hand, for business owners, it means that non-compete clauses continue to be a tool that you can use in your agreements, depending on your state. But keep in mind that courts are scrutinizing these types of clauses much more closely now. A poorly drafted non-compete agreement or clause could get thrown out in court, so it's important to make sure that yours is drafted to be legally sound. Even though the federal ban was struck down, I'm sure we're going to see more reform around non-compete agreements, both on the state and federal levels. So stay tuned because it's likely that this issue is going to continue to evolve. But whether you're an employee or a business owner, TLO will continue to keep you updated on the latest legal changes that could impact you. So with that said, that's all I have for this video. Don't forget to like, subscribe, and share with a friend. Let me know in the comments how you feel about non-compete agreements. Do you think they should be banned nationwide, or do you think the states should have the final say? And as always, this is Talbert Law Office, your favorite go-to legal resource for all things business, nonprofit, and intellectual property law. Thanks for watching, and I'll see you in the next video. Bye. I done made